Lords, I'd just taken you to the Trattamento case.
Yes.
And I was going to ask you just to look at one more authority before I make my points on the distinction between the LMA wording and this clause. It's another BNB Paribas case against Anchorage Capital, and that's to be found at tab 17 of Authorities 1, page 292. Decision of Mr. Justice Mayles. Tab 17. And if I could ask you to look first of all at page 312. Where you'll find at paragraph 83 the clause in question, and ask you to note it is an asymmetric jurisdiction clause. Only Anchorage irrevocably submits the English jurisdiction. I could then ask you to go over the page and read to yourselves paragraphs 88 through to 91.
Yeah.
If I could ask your Lordships to, in particular, draw your attention to page 314, about 9 lines down in paragraph 91. At the start of the line, His Lordship says this: "It would make no sense, in my judgment, to construe the clause as permitting anchorage, so long as it submits the jurisdiction of the English courts also to bring a claim of its own in New York, in respect of essentially the same matters as arise here. Cannot sensibly be supposed the parties would have regarded such a prospect as acceptable. On the contrary, they would rightly have regarded it as a procedural matter." Now, that decision of Mr. Justice Mayles has been followed in 3 subsequent cases using the one-stop shop presumption to determine whether there is an agreement that proceedings should not be pursued other than in the nominated court. And we give the references to those 3 subsequent first instance cases in paragraph 34 of our skeleton. That's Core Bundle, tab 4, page 28L. I don't propose to take you to those cases which effectively say draw the same conclusion. And with those principles in mind, I turn to the wording of clause 14. Now, I emailed through this morning a 1-page summary which puts the LMA standard asymmetric wording in clause 14 side by side. I can hand up copies if that would assist. If your auditors have got it, then there's need to. In our submission, there are 7 distinctions between the LMA wording and the wording in this case, which both individually and cumulatively make a material difference. First, the LMA standard wording does not require the borrower to submit to any court other than England. It is purely permissive. That was a material part of the reasoning in the Mauritius Commercial Bank case. And if you've still got Authorities Volume 1 open, it's the previous tab, the Mauritius Commercial Bank case. And it's at paragraph 37 on page 289. And it's the sentence at D. Now, in contrast, clause 14 contains an express promise by Hipgnosis to submit to the jurisdiction of the courts in Los Angeles or New York if selected by Mr. Manilow. In that respect, it is mandatory. As we point out in paragraph 42 of our skeleton, Core Bundle tab 4, page 28N to 28O. Now, this distinction was explored by Professor Marshall in her recent monograph on asymmetric jurisdiction agreements. For this purpose, can I ask you to go to Authorities 3, tab 56. Starts at 1522, but if I could ask you to go to 1569. And to read paragraph 7.19. The reference to arguably is explained in footnote 64 at the foot of that page, where it refers to Mauritius Commercial Bank and Professor Fentiman's work. That footnote contemplates 2 things. 1, legislation to the contrary, and 2, potential difficulties if the submission is to all courts worldwide. Neither of those applies here, no contrary legislation has been identified, and the submission is only to 2 states, 2 courts in the US, not worldwide, 1 of 2 courts. Professor Marshall makes a third point back in the body of paragraph 719, last sentence, which is the ability of the non-option holder to counterclaim in the chosen form. And what we say about that is this: any counterclaim which is not a purchase price claim would of course still need to be pursued in England. Phrase 4 only overrides phrase 2 on purchase price claims. As for a purchase price counterclaim, for example, a counterclaim for different declarations or a restitutionary claim for overpayment, we say this is resolved by the construction plainly to be given to notwithstanding the foregoing. And for your note, that's our skeleton.
Sorry, how does that work? I'm not sure I'm following that.
As we have said, if I can just, it's best taken up by reference to our skeleton, paragraph 41, and footnote 12, that's tab 4 of the core bundle, 28N. Where we say, appellant's wrong, say the words notwithstanding the foregoing in phrase 4 should be read as overriding only some of the negative terms of phrase 2 and none of its positive terms. We refer to skeleton. Those words can be read on their ordinary and natural meaning as overriding both types of terms in phrase 2. And we refer then to the footnote where we say the suggestion to the contrary in para 11.4, my friend's is wrong. On this construction of clause 14, the appellant would be entitled to counterclaim in the Californian courts because the effect of exercising the option under phrase 4 is to override the relevant part of the negative term in phrase 2.
Sorry, which bit of phrase 2 is overridden?
Exclusivity. Exclusivity.
So the word exclusive is excised?
It's overridden, yes, in those circumstances.
In phrase 2?
As my Lord Justice Snowden, we submit, rightly observed. And then we go on to say, as a matter of commercial common sense, those words should be read that way as overriding both types of term in phrase 2. The answer to the question posed by Mr. Justice Males in Anchorage and Mr. Justice Butcher in Deutsche Trustee must be that there is no clear indication in the text or context to suggest that the parties signed up to the procedural nightmare of parallel duplicative proceedings. And in those circumstances, the Fiona Trust presumption ought to prevail. And we say there's a material difference to the standard LMA terms, as in Mauritius Commercial Bank, which expressly refers to the possibility of concurrent proceedings. So leads to a different answer to the question posed.
Why do you say that the parties, there's no indication to suggest the parties signed up to parallel duplicative proceedings? I mean, they certainly signed up to the possibility of 2 sets of proceedings relating to very closely connected matters.
Well,
in the sense that you have a right you say to bring claims related to the purchase price in the US.
Yeah.
But it must follow that any other type of claim which might be brought by
Hipgnosis, yes.
Hipgnosis, would have to be litigated in in England, and there's every likelihood if your client sued for the purchase price, there would be claims brought going the other way with some assertion of set-off.
Well, it's absolutely right that the parties plainly contemplated the possibility of parallel proceedings, one in England, one in either California or New York. But my submission is what they plainly did not contemplate as business-like commercial people was that the same dispute in relation to the purchase price, which was carved out by phrase 4, would be litigated in both England and
Well, just think about that. I mean, I know it's not quite the facts of this case. But assume there's a claim for this for the what are called the Sony receipts or whatever they're called in England, and your client's defence to that claim is you owe us the additional purchase price, which in a sense is I mean, you haven't filed a defence, but that's essentially your case or part of your case, and to which the claimant's answer is actually there's no additional purchase price owed at all. That's just nonsense. There isn't any. All of which, in order to resolve the dispute about whether they're entitled to the receipts, those matters would need to be resolved in one jurisdiction in England. And the idea, what you seem to be saying, is that argument that there's nothing in the purchase price claim is effectively a counterclaim that should be brought in Los Angeles. And the attempt to carve up everything to do with the purchase price and shove it into Los Angeles doesn't work, does it?
with great respect, it's what the parties plainly agreed to and intended.
Well, it
And-
may be
and
what
just to
parties
answer-
agreed to in one sense, but if what you're doing is saying, I mean, your argument here is this: it is, you know, it's unthinkable or whatever the right word is that the parties would have agreed parallel proceedings. But the point I'm putting to you is actually the logical consequence of your argument is even worse. It means the English court can't, on this hypothesis, determine the dispute in England.
Well, my lord, would you put a hypothesis to me as to what might happen in relation to the purchase price claim? But let's look at what actually happened. The royalties claim was brought together with a claim for a negative declaration. Mr. Manilow challenged the right to bring that claim for a negative declaration, seeking to exercise his contractual right, we say, to have that purchase price claim determined in California. Now, he therefore couldn't. He could have submitted. He could have declined to exercise that option. Could have submitted to the jurisdiction of this court and put in a counterclaim for the additional purchase price. But
Well, in Mr. Cullen's case, he'd be perfectly entitled to do that because it falls within the second. Falls within the second
of course,
sentence.
and in which case, phrase two.
On the hypothesis you're putting to us now, which you said a moment ago, phrase 2 is overridden so far as a counterclaim is concerned. The effect of commencing the proceedings in the United States is that any claim in relation to the purchase price is excised from the English jurisdiction. Any claim or counterclaim.
Absolutely, only where the option is exercised.
Oh yeah.
And that option has been exercised. Now, what Mr. Manilow could have done is said, right, I'll deal with the royalties claim by putting in a claim for counterclaim set off in relation to the purchase
Well,
price.
depending on what the result of this appeal is and what happens in Los Angeles next week, Mr. Manilow might yet be in a position where in 2 weeks' time or 3 weeks' time, the advice he's given is that you're better off litigating this whole dispute in England.
Well, my lord,
Because you can litigate everything there.
he's admitted that royalties claim. He's admitted it.
Well, you
Or-
say
or-
that, but it's not
well, he
entirely
has.
clear that he has.
Well, it is, my
There's
lord.
still one bit of it that isn't admitted.
No, my lord. He's admitted a claim. He's admitted the claim. I can take you to
Well,
the
if he's got a
relevant
if
correspondence.
he's got a claim for fraud, and the American court would say that's a claim that should be brought in England.
That's a matter for the American court, in my respectful submission. But so far as the claim here, what I've called the royalties claim, you can call it the Sony receipts claim, that is admitted, and I can take you to the letter. My learned friend did show you it this morning. But effectively, there is no dispute in relation to that. All that needs to be determined is that there is going to be an account if the parties can't agree. Already $500,000 has been paid over. The parties can't agree as to the balance. That account will be taken. That was the only relief sought, and it's been admitted. So all that is left is the declaration, and the negative declaration in relation to the purchase price, in respect of which Mr. Manilow's exercised his own. So my lord, if I can just deal with this counterclaim point, where I've taken you to paragraph 41 and footnote 12. We submit that that is the proper construction of the words notwithstanding the foregoing, because of the procedural nightmare that would otherwise follow per Mr. Justice Mayles and those others who followed him at first instance. And that brings me to the second point, because the two wordings contain different linking words. The LMA standard wording provides that the exclusive jurisdiction agreement is solely for the benefit of lenders. That's clause 24.1c. As you will see. And so the lenders are not bound by it. That wording is explained by Professor Fentiman in International Commercial Litigation, which, for your note, you'll find the relevant paragraph is 2.130. That's Authorities 3, tab 51, page 1444. I'm going to summarize that because I don't have that much time. Firstly, as Professor Fentiman explains, that reflects the words of Article 17 of the Brussels Convention, although it was dropped in the Brussels regulation. It also reflects the fact that the LMA wording permits the bank to sue elsewhere, but does not mandate the borrower to accept the jurisdiction of that forum. By contrast, Clause 14 adopts a different approach. It introduces an internal hierarchy within the jurisdiction agreement by the words notwithstanding the foregoing that subordinates phrase 2 to phrase 4. And the essential issue between the parties on this appeal is the extent of that override. And that's my Lord Justice Snowden's point. Do these three words override just Mr. Manilow's negative obligations under phrase 2, and so lead to a similar result as the LMA wording? In other words, do they enable Mr. Manilow to bring a claim related to the purchase price in the courts of California and New York, but yet not prevent Hipgnosis from bringing such a claim in England? Or do they override phrase 2 more generally, requiring, if Mr. Manilow so chooses, both parties to submit the purchase price dispute only to the courts of California or New York, to the exclusion of other forms.
Well, I think we've got that point with respect.
Well,
I think that's a,
my lord, yes, that's the critical point.
what you're doing is, at the moment, is pointing out to us the differences between the two provisions.
Yeah, exactly, and just to follow through on that, it plainly, phrase 4, plainly overrides exclusive jurisdiction. We submit it also plainly overrides irrevocable submission, because the parties agreeing to submit to jurisdiction elsewhere.
But only in relation to claims made by D against C.
But my lord, it's in that context that I say that a counterclaim, if there is one to be brought, and here it is only a negative declaration. But suppose, take an example, there was a restitutionary claim. Mr. Manilow had brought a claim in relation to the purchase price, then the counterclaim, we would say, applying the authorities on the one-stop shop presumption stemming from Fiona Trust, is also to be brought there.
But the point here, though, is your argument is that notwithstanding of the foregoing is an exception to the exclusivity and the submission. But when you look at it, but notwithstanding the foregoing doesn't stand by itself. It is any claims made by D against C may be brought. So that's the carve out. It's not any. It doesn't say any disputes relating to the purchase price must be brought, or must at the option of Mr. Manilow be brought. It just doesn't say that.
No, I accept that.
So you're completely rewriting the clause.
No. With respect, I'm not. What my submission is, and I've always accepted, both below and in this court, that unless that option was exercised by Mr. Manilow, a claim related to the purchase price could be brought by either party in this jurisdiction. But what I'm submitting is that once Mr. Manilow has exercised that option, it's not a temporal limitation, as I come on to explain.
That is, as my lord just put to you, the logical consequence is once he exercises the option, any claim in relation to the purchase price must be brought in the US.
Yes, absolutely, I do say that. By either side, It's not just a negative.
Why does it, how does it affect a claim by the claimant? It doesn't deal with a claim by the claimant, it only deals with a counterclaim. So if you take the example that was postulated by Mr. Cullen of a restitutionary claim because they overpaid the purchase price by mistake. So it's not a counterclaim, it's a claim for the return of money in relation to the purchase price. So it falls within the words a claim related to the purchase price, but it's not a claim by Mr. Manilow, it's a claim by the claimant.
No, that's brought under phrase 2.
So that falls under phrase 2, come what may, is that?
No, my lord. You give the example, and I gave the example of a restitutionary claim. We had, on the facts of this case, a claim for a negative declaration. So the question is, and that they were entitled to bring it, subject to conduct issues, which is discretion, but they were entitled to bring it in this country. But what is the effect of the exercise of the option in phrase 4? And we say plainly the construction is not only does it override the exclusive jurisdiction provision, but also the irrevocable submission, because it plainly contemplates the purchase price dispute, the claim from Mr. Manilow, which would it be in existence as a result of the exercise of the option, and any counterclaim. As it happens, there is no counterclaim in restitution. There's only a counterclaim which is the mirror image of the claim. They just take a different view as to construction. So they say negative declaration, we say declaration that they're liable. And that has to be brought in California and New York.
Let's imagine that the claimant has a claim in relation to the purchase price for overpayment, or maybe for being induced by misrepresentation or fraud to pay the price. They bring that claim. Do you then say that you have the option to have that dispute in Los Angeles?
If Mr. Manilow brings a claim
But how does he do
in
that?
relation to the purchase price, well, he's done that.
No, but I'm saying in that situation, how does he do it? Because he hasn't got a claim for the purchase price. Because he's been paid the purchase price.
Well, he hasn't been paid the 1.5 million that he.
No,
Sorry.
on this
No.
hypothetical,
I see.
hypothetical example, you've been paid the purchase price, but there was a claim by the claimant to recover it, say on the basis that it's been payment was induced by fraud or misrepresentation, or they paid too much. So you have not got a claim for the purchase price because you've been paid it.
Yes.
So how do you exercise your option?
Well, we would seek a declaration that we had not.
You
Defraud.
seek a negative
You seek a negative
declaration. So
declaration.
negative declaration in Los Angeles.
Just
And
to
this
use
isn't a
my lord's-
procedural nightmare?
No, my lord, because it would be a dispute that was being determined in the place. It was the purchase price dispute. The parties have agreed will be determined in California and New York. If Mr. Manilow chooses to bring that declaration on those facts. So what we say is that notwithstanding the foregoing is not qualified in any way. It has the effect of writing both the negative and the positive terms of phrase 2. And the words used by the parties also don't contain any temporal limitation. There's no language, for example, to suggest that the option under phrase 4 is lost if proceedings in respect to the purchase price are commenced first under phrase 2. I accept that the option could be waived if it wasn't exercised promptly. But that is not these facts. There's no suggestion of any waiver. So the point simply doesn't arise for determination. Indeed, the point appears to be agreed by my learned friend. If I can just refer you to paragraph 10.3 of the skeleton. Tab 3, page 22 of the core bundle. Where you will recall he disclaims any first past the post argument. So my learned friend doesn't suggest that by activating the jurisdiction agreement in phrase 2, the jurisdiction agreement in phrase 4 was closed, and that's rightly so in our submission. Further, the one-stop shop presumption, in the sense it was applied by this court in Trattamento, operates in this context. The parties did not intend to permit duplicative parallel proceedings with a risk of inconsistent judgments. And that also points towards a full override of phrase 2 in respect of purchase price disputes, where the option is exercised under phrase 4.
Only in respect of purchase price
Disputes.
disputes,
Yes.
not anything else that might be closely connected, related, or otherwise to them.
No. It's significant.
I mean, your US lawyer who wrote that the infamous Peanuts letter didn't sort of have much truck with one-stop shop, did he?
I'm afraid I can't quite envisage what he had in mind.
Well, he
by
plainly had
using
in mind.
that
He
phrase.
plainly had in mind, we'll sue in the US and you can sue for peanuts in the UK. I mean, it doesn't sound very one-stop.
Well, the parties plainly envisaged parallel proceedings in relation to different disputes arising under the agreement. There's no doubt about that. And it's significant, and this is
No matter
the
how
important-
closely connected those disputes were.
Well, the royalties claim is a separate claim. There's my friend's primary case on that is no right of set-off. So whether it's closely connected or not is a separate claim. But what's significant in my submission is that phrase 4 doesn't just permit Mr. Manilow to start proceedings in the US, but it also requires Hipgnosis to submit to those proceedings. And in the absence of clear words to the contrary, the parties cannot sensibly be taken to have agreed to submit to both courts for the purpose of the same issue being litigated in two places. That would be a wholly uncommercial and unbusinesslike agreement to
I
enter
thought
into.
you've shown us authorities which say that that may be the result of the construction of the clause. Yes, it was clear.
That's where it was clear, my lord, and I'm coming on to that in my third point. But just finishing off with this second point, phrase 4, properly construed, must therefore be read as revoking the submission to the jurisdiction of the English court in phrase 2, if Mr. Manilow elects to bring a claim related to the purchase price. And my third point is that the LMA standard wording explicitly refers to concurrent proceedings without qualification. Just looking at that.
Yeah.
You'll see it's the last sentence of subparagraph C.
Yep.
That there's no such word in clause 14. That's significant because the LMA wording expressly contemplates parallel proceedings which rebuts the one-stop shop presumption, at least to some extent. And in contrast, in the absence of such words in clause 14, the court's starting point should be that the one-stop shop presumption still applies in its narrower tratamento sense, which is that the parties are unlikely to have intended that the same dispute on the purchase price could be pursued in parallel proceedings on both sides of the Atlantic. The fourth distinction is that the LMA standard wording permits the lender to litigate in any other court worldwide. That was a material factor in Mauritius Commercial Bank, and you've already been shown the relevant paragraph by my friend. It's at Authorities 1, tab 16, 289, paragraph 38. In contrast, phrase 4 of clause 14 simply allows Mr. Manilow to sue at home. The choice is limited to England and the US, specifically California or New York. It's nothing like the exorbitant or very unreasonable result that was of concern to Mr. Justice Popple. And the word or between Los Angeles or New York in phrase 4 is significant. It should be read disjunctively. Mr. Manilow can sue in respect to the purchase price in Los Angeles or New York, but not both. Phrase 4 does not permit concurrent proceedings in two different states in the United States. That is a broader textual indication as to what the parties envisaged as to parallel proceedings. They plainly did not contemplate or agree to duplicative parallel proceedings with a risk of inconsistent judgments on the purchase price dispute. Fifth, the LMA standard wording at clause 24.1c does not limit the types of action which the lender can bring outside England. In contrast, phrase 4 provides that disputes relating to the purchase price can be submitted in California or New York. All other disputes remain subject to phrase 2. And again, importantly, the language contemplates the submission of such dispute in California or New York. And we say that provides a further textual indication that where phrase 4 option is exercised, it's intended to be the only forum in which the purchase price is litigated. This is sometimes put in terms of a distinction between the transitive and the intransitive. And that distinction has been followed in a number of cases. And in particular by Mrs. Justice Dias, as she now is in the Commercial Court in the GDE decision. We've given you the reference, footnote 9 of our skeleton, page 28K. The matter can be tested in this way. By phrase 4, the parties said, in effect, we intend purchase price disputes to be litigated in California or New York if that is what Mr. Manilow wants. If the officious bystander had asked at the time of contracting whether a purchase price dispute could also be litigated in England in tandem with California or New York, that would have been met with, of course not. Now, my 6th and 7th points are not determinative. They simply contribute to the first 5 points and support our construction. The 6th point is this: the LMA wording requires each party to confirm that English courts are the appropriate forum and promise not to argue to the contrary. That's clause 24.1 little b. In contrast, no such promise is made in clause 14 in this case. And the omission of a provision equivalent to clause 24.1b is consistent with the addition of the promise by Hipgnosis to submit to proceedings in Los Angeles or New York. They're two sides of the same coin.
Well, it doesn't get you very far, that point, because, leaving aside clause 4, or sentence 4, each party irrevocably submits for all purposes of this agreement to the exclusive jurisdiction of the English courts. If that just stood on its own, you'd have considerable difficulty in running an argument of foreign non-convenience.
Absolutely.
It's just not
Absolutely.
it's just, the LMA wording is, the wording of the exclusive jurisdiction clause bit of it is much looser than in this case.
Well, my lord, that is the key difference, which is phrase form,
Anyway,
the
we've got that
notwithstanding the
point.
foregoing, because the parties have agreed that either Los Angeles or New York would have jurisdiction to determine purchase price disputes. So in those circumstances, they could not have agreed to wording equivalent to 24.1b, that the English court was the appropriate forum for any dispute that would arise from the relationship. And then the seventh point, and again, this is not determinative at all, but another, we say, support of the construction is that the wording, the LMA wording, contains a provision for service in England that's relevant given jurisdiction in English law is based on service and avoids the need to serve out of the jurisdiction. In contrast, there's no such provision in clause 14, and the closest one gets to a service provision in this case is the notification provisions in clause 9. That's page 31 of tab 3A of supplemental bundle. And under clause 9, Mr. Manilow required notification at home in California, copied to his New York attorney. And we
Well,
say
that can't be a relevant distinction for present purposes. I mean, it is a distinction between two clauses, you're right. But it's of no relevance to the present considerations because of the presence of an exclusive jurisdiction clause. The claimants were entitled to serve Mr. Manilow and the company in the United States without seeking permission. So it was a case in which permission to serve out wasn't needed. So it's just a location of the service. I mean,
it's simply
it's a distinction.
It's a distinction,
it's a
and
meaning,
I'm
so-
not placing that much.
Okay.
The distinctions, particularly the first 5, in my submission show this clause 14 is entirely different to the LMA wording, and they support the learned judge's conclusion that Mr. Manilow's exercise of his option to start proceedings in California concerning the purchase price must result in the stay of proceedings in England concerning the same issue.
Okay.
Now, those are my submissions on construction. I now hand over to my learned junior, Mr. Day, to deal with the fallback issues on the Hague Convention and the exercise of discretion if my lords are not with me on construction.
Yes, Mr. Day.
My lords, we say that the Hague Convention, on its proper construction, does not apply to asymmetric
Well, we
jurisdiction.
didn't need to decide that issue.
Well,
Because if Mr. Cullen's right, then it doesn't arise, and if you're right, it doesn't arise either, does it? Unless how does that work? I mean,
well, my lord, the way I understand it is much like
if your construction, if Mr. Sutcliffe, if the construction that's been urged upon us this morning, this afternoon, is correct, then this isn't really an exclusive jurisdiction clause at all.
my lord, that's correct.
None of it is.
And
If you're right about that, then the Hague Convention can't apply.
that's why it's a fallback to my learned friend Mr. Sutcliffe's submission. So I'm hoping what I'm going to say is academic because you've been holding
I mean,
persuaded
just
by it.
the reality is that you know the they're sort of travaux preparatoire, the report of the 2 professors
Yes,
indicates it doesn't apply to asymmetric clauses.
yes,
There have been some dicta along the way
yes.
from English judges rather doubting that, and you've got Professor Briggs in his various volumes doubting that as well. But unless we need to decide that point.
Well, my lord, I think logically the sequence is if you're with my learned friend Mr. Cullen, that on his construction, that this dispute falls within the exclusive jurisdiction
just
of
as
the
a
English.
matter of law and as a matter of contractual construction.
Yes, as a matter of construction. Then the Hague Convention comes first, because if my learned friend is right on the Hague Convention, there's no discretion. The court has no discretion under Article 5.2 of the Hague Convention to even entertain the suspicions that I might want to make about inconsistent judgments and whether that acts as a strong cause for declining jurisdiction. I have to win on the Hague Convention for my lords to get to the point where they're willing to consider whether there is a discretion not to enforce the jurisdiction agreement in line with my learned friend Mr. Cullen's
Alright,
construction.
okay,
So
David.
this may actually be the first case where the ratio of the case
Keep
includes.
it short, because I don't think much to be gained from the Hague Convention.
My lord, that's noted. I will do my best to cut my cloth. Can we just briefly go to the Hague Convention in that case? That's in the Authorities Bundle, Volume 3, tab 44. And Article 3A is on page 1246.
Sorry, Article
3A is on page
3A.
1246. And that contains the definition of an exclusive choice of court agreement for the purposes of the Convention, which requires the designation of the courts of one contracting state to the exclusion of any other court. So my lord, see that was in the fourth and fifth lines of 3A. And then if one goes over the page to Article 5, Article 5.2, then in effect requires this court to accept jurisdiction and it can't exercise any discretion not to exercise jurisdiction in those circumstances. That there are no lis pendens rules under the Convention for exclusive choice of court agreements, and that's because the Convention doesn't contemplate that more than one forum can be chosen by such an agreement. We then go to page 1250. My lords will see Article 22, reciprocal declarations on non-exclusive choice of court agreements. So a contracting state may make a relevant declaration. And can I just draw my lord's attention to the definition of a non-exclusive choice of court agreement? So that's where disputes which have arisen or may arise in connection with a particular legal relationship, a court or courts of one or more contracting states. That's what constitutes a non-exclusive choice of court agreement. And where that applies, one sees over the page on 1251 that lis pendens rules are introduced in paragraph 2 of Article 22. Now, my learned friend obviously doesn't rely on Article 22 because the UK hasn't made any relevant declaration, but it is relevant for two reasons. Firstly, that definition that we've just seen, which we say must give colour to the definition in Article 3A. If a jurisdiction agreement meets the definition in Article 22, we say it cannot also fall within Article 3A. We say the drafters must be taken to have seen those two forms of choice of court agreements as being mutually exclusive. And then secondly, the point I've already made, that in those circumstances, lis pendens rules don't apply for what the Convention sees as exclusive choice of court agreements, because it just simply wouldn't arise for the type of agreement which the Convention sees as being exclusive. And then finally, on the Convention itself, Article 23 requires a uniform interpretation. Now, as that suggests, the Hague Convention should be construed as an international instrument, not as a domestic statute. And so by reference to the principles in the Vienna Convention, I'm not going to go in detail, given my lord's indication, as to the principles of construction, but the relevant articles, as my lords will know, are Articles 31 and 32.
Yeah, that's in the Vienna.
Yeah, in the Vienna Convention, exactly, it's in the previous tab. Article 1 tells us to focus on the terms of the treaty in light of its context, object and purpose, that's paragraph 1, and that the court can take into account connected agreements, that's paragraph 2. And then Article 32 then permits in certain circumstances an assessment of the travaux. So Article 31 contains the general rule and Article 32 has a supplemental rule, which is more limited.
There's only to confirm though, isn't it?
Sorry,
There's only to confirm the meaning.
it can either confirm or determine.
That's only if there's ambiguity.
Yeah, my lord, that's absolutely right. So, and this is the point that Lord Hamlin addressed in the JTI case. If it's confirmation, then one can look at the travaux. If it's to determine, in the case of ambiguity, it has to be a bullseye. Otherwise, it's not permissible to look at the travaux. Now, in those circumstances, we say an important issue for my lords to decide on this appeal is whether the Hartley-de Gauci report forms part of the Travo, and so falls within Article 32, or amounts to relevant context as a connected agreement or instrument, which falls within Article 31. And in my submission, the report is not part of the Travo because it's not generated by the negotiation of the convention, but it's officially published alongside the convention. And in support of that submission, can I briefly take my lords to two commentaries on the Vienna Convention? The first is in tab 50 of the third authorities bundle, if my lords still have that.
Yeah.
This is the Dorr and Schmallenbach commentary. And within that, at page 1429, at paragraph 63, the editors say, it's about 4 lines down in paragraph 63, it's left unclear how the distinction between extrinsic context and the preparatory works of a treaty can be drawn in any given case, and they say it's submitted that the distinction hangs in the phrase in connection with the conclusion of the treaty, so it's a timing point. In other words, if the document is made in connection with the conclusion of the treaty, it leaves the Travo behind, it leaves the preparatory stage behind, so it falls into Article 31. And if one turns the page to 1431, page 66, my lords will see at the foot of page 66 before the examples, that it's paragraph 66, I'm sorry, paragraph 66 on page 1431. There's a reference there to explanatory reports as being the type of thing that can fall within Article 31, paragraph 2. Gives a list protocol with understandings, commentaries, or explanatory reports. And then if one goes forward to tab 54, just briefly, page 1486. This is the book on treaty interpretation by Richard Gardner. In fact, if one starts at 1483 by the red sideline, the author makes the point that reports look to be context by virtue of their endorsement at the time of the conclusion of the treaty, whereas in contrast, International Law Commission commentaries aren't endorsed, and so they remain part of the preparatory work. And he then returns to that point on 1486, on turns of page, where my lords will see at the bottom of 1486, there's a reference to the ILC commentaries, and then a distinction is drawn between those and the Hague Convention reports on page 1487. The author says, of those specifically endorsed at the time of the conclusion of treaties, prominent examples include those relating to conventions drawn up by the Hague Convention of Private International Law. So, my lord, in those circumstances, we say the report is got to be given quite a lot of weight because it falls under Article 31, not 32 of the Vienna Convention. I've given various references to the report in the skeleton argument, but I'll just take my lords to the bullseye point, as it were, in all submissions, and that's the stick in the third volume of the authorities bundle.
Yeah.
The report is at tab 46.
Yeah.
And if we go within that, page 1326. 1326. Can I ask my lords to read paragraphs 105 and 106?
I'm not referring to all this to, this is to meet an argument which Mr. Cullen didn't advance before us, did he?
I don't think, I'm not sure to what it certainly advanced in the skeleton
All he actually
argument.
referred us to, as I understand it, were these comments saying, referred to the fact that there were references in the Travaux to the treaty not applying to asymmetric agreements. So I'm not really sure what exercise we're engaged in now, other than I'm not sure what exercise we're engaged in.
My lord, if my learned friend Mr. Cullen isn't taking a point on the Hague Convention, then I won't
Well,
proceed.
I think as I understand it, this is all to do with some argument you've got about discretion, which you haven't yet advanced. But
Yeah, well, formally, I think Mr. Day is right in the sense of the logic of it goes, that if you're with me on construction, then the question is there a discretion to be exercised? If the Hague Convention applies, then there isn't.
yeah,
And that's not an argument, and I'm persisting in the argument that it does apply, although I didn't develop it very much.
no, I understand.
Because when one gets to the final stage, if I'm wrong on the Hague Convention, one gets to discretion. And we say at that point, it's so clear that there is,
Well, you
wouldn't
say, as
exercise
I understood
discretion.
your submissions this morning, you don't need the Hague Convention, because if you look at the second sentence, it just doesn't allow for any sort of, as it were, residual discretion.
Indeed, coupled with various merits-based points about fraud and that sort of thing. But essentially, yes. So I didn't develop the argument on
No,
the Hague Convention because I didn't really want to waste the court's, or take up the court's time.
No.
And if the court feels that it doesn't need to deal with it, then that may be the sensible approach.
Well, I think we should hear what Mr. Day wants to say about discretion, but, I mean, we'll, as it were, I don't think we're going to be deciding that the Hague Convention does apply, if we don't have to.
I'm not going to
If
encourage the court to decide if the court
the
doesn't.
whole appeal turned on that question, then we would have to decide it.
Yes.
But since it doesn't turn on that question,
There are much easier ways for the court to get through this.
it's quite a, from the point of view of this court, it's quite sensible not to decide issues you don't have to decide.
Particularly in the context of an expedited appeal.
Okay.
My lord, I'm grateful, and that's clear enough on the basis that it's not going to be held that there isn't a discretion, and I'll move on to
Yeah, okay.
the discretionary.
Make submissions about why you said there's some discretion to cite.
My lord, yes, and on that, we say that parallel proceedings are not just about the convenience of the parties,
Sorry, not just about what?
what's convenient to the parties. So it's not like some of the factors one considers in an application of this nature, such as language or location of witnesses or documents or whatever it may be. We say that the risk of inconsistent judgments at the end of such parallel proceedings raise problems about the interest of justice and public policy. And to make that proposition good, can I take my lords firstly to the Almeria, which is in the first volume of the Authorities Bundle, 14. Sorry, it's page 14, it's tab 4. Within that, it's page 30. My lords will see on the right-hand column, Lord Justice Brandon refers to what the learned judge below in that
What
case.
page are we on?
Page 30. Page 30, right-hand column. My lords will see that Lord Justice Brandon refers to what the learned judge in that case said below, where he said it would be a matter of great convenience if that action could be tried at the same time as this action. So in other words, it would be convenient to avoid parallel proceedings. And Lord Justice Brandon endorses that, but he says, I would go rather further than he did in the passage from his judgment quoted above. By that I mean I do not regard it merely as convenient the two actions, in which many of the same issues fall to be determined, should be tried together. rather that I regard it as a potential disaster from a legal point of view, if they were not, because of the risk inherent in separate trials, one in Egypt, the other in England, that the same issues might be determined differently in two countries. And a similar point is made in the City March case. That's tab 8 of the same volume. 8A, I'm sorry, 8A.
This is City March, yes.
This was an asymmetric jurisdiction clause case. My lords will see that on page 92, where the clause is set out. And then the relevant issue is picked up at page 98. And just above letter D, Mr. Justice Coleman refers to a highly unsatisfactory procedural situation in which the action against the first defendants must be pursued in Singapore, whereas the English actions against the second, third and fourth defendants must be continued here. And then as a separate point, F in the new paragraph, in addition, there is a risk if actions in respect of the same loss must be brought in different jurisdictions that there will be inconsistent decisions on the same facts. And then he refers to the Almeria again. And then over the page, on page 99, D, he confirms that considerable weight should be given to that. And then my lords will get the conclusion at H, consideration of those factors, foremost amongst which, although not the only factor, was the risk of inconsistent judgments. Did in Mr. Justice Coleman's view tend to the view that strong cause is shown for a trial in England to avoid that risk. Now, my learned friend's answer to this, as we understand it, is that on his construction of clause 14, duplicative parallel proceedings were foreseeable. And we accept, of course, that foreseeable factors of convenience, so location of witnesses, language, etc., are not typically sufficiently strong causes to decline to exercise jurisdiction in the face of an exclusive jurisdiction clause in favour of the English courts. But we submit that the risk of irreconcilable judgment is more than a problem of convenience. As we've seen, Lord Justice Brandon referred to it as a potential disaster from a legal point of view. And the facts here make the risk of inconsistent judgments a strong cause for staying these proceedings. This is not a case where the risk is a limited one, where there is only limited overlap between the two sets of proceedings. The declarations sought are diametrically opposed to each other. My learner friend Mr. Sutcliffe took my lords to the declaration sought in England earlier. That was in the prayer to the particulars, paragraphs 1b and 1c. I'm not sure my lords have seen the declaration that's being sought in California yet. Can I briefly take my lords there? That's in the supplemental bundle. Tab 3E.
Supplemental bundle.
Tab 3E, page 64.
Right.
And in the prayer there, one will see it too, the judicial declaration that's been sought from the Californian court. Now, given the terms of the declarations being sought here and there, the risk therefore arises that there will be fundamentally inconsistent judgments in circulation in the US and England, preventing the recognition of a Californian judgment in this jurisdiction, and presumably giving rise to comparable difficulties about the recognition of declarations made by this court in California. And that matters because those are the two jurisdictions that matter. Hipgnosis is an English company, and Mr. Manilow is an American citizen living in California. And his management company is also a US company. So if both of these proceedings continue in parallel, the result would be a legal stalemate, with one judicial determination, could be a legal stalemate, I should say, with one judicial determination as to the purchase price in Mr. Manilow's jurisdiction and another in this jurisdiction. And of course, in those circumstances, there would be no available mechanism for resolving the conflict between the two jurisdictions. There's no applicable convention that could deal with that conflict or resolve it.
This is a position that you have brought about, isn't it?
Well, I'm going to come on to that, but we don't quite accept it's in those terms. But let me just finish this point, and I will come on to that point if I may, my lord. So in other words, rather than bringing finality to the dispute between the parties, we say the risk is that the dispute becomes permanent and paralysed by conflicting judgments, and that's obviously the opposite to what litigation is meant to achieve. Now, coming to the question of fault, if I may.
Before you do that, sorry, I know I asked about that, but in relation to the factors, and surely the major factor, well recognised, is that this is an agreement governed by English law. And so if there is a question about which court should be the one that determines these issues, then prima facie the English court is the better place to do so.
Well, I accept that's a factor that counts against us.
Well, a very strong factor, isn't
And
it?
it's also a factor taken against us in the Californian proceedings. And there's a debate about the strength of that factor in
You're
California.
submitting here to us that we ought to stay this claim governed by English law with an English exclusive jurisdiction clause in favour of proceedings in the United States that would also have to determine it according to English law pursuant to a clause that isn't exclusive.
On the basis of expert evidence of English law. I mean, it's quite clear from reading the complaint that that's what's contemplated. There will be expert evidence of English law in California proceedings.
Well, my lord, that is I'm not sure it's quite as settled as that in California, but we're not in a position to say how foreign law would be adduced in California and whether one would make submissions on it or
I
not.
think I picked up somewhere that what's contemplated is the expert evidence, but maybe I'm wrong.
Well, my lord, can I just show my lords in that case one document or one passage in the supplemental 2 bundle, this is the unagreed bundle.
Yeah.
Tab 2, page 46.
Sorry.
These are the submissions made by Mr. Manilow in response to the motion to dismiss.
Yeah. Sorry. Page
46. There's a heading, familiarity with the governing law. And some submissions are made there about the willingness of the US courts to deal with issues of English law and whether the claims at issue actually implicate any unique issues of English law at all. Now that's obviously a matter to be determined on the 18th of April. I simply show my lords that to make clear that it's not accepted, that there are uniquely English issues, legal issues arising necessarily. Ultimately, one is reading the terms of the contract.
It's clearly easier for an American court to decide issues of English law than to say for a Russian court, but nonetheless it's foreign law.
My lord, yes, and I accept that that's a factor against us. My submission is simply that that is outweighed by the perils of inconsistent judgment in this
Much
case.
experience of dealing with American law over the years. It's sometimes an error to assume that the two systems are necessarily the same.
My lord,
Anyway, you've got the point.
yes, and I'm not submitting that they are
No.
the same. Now, my learned friend doesn't suggests that Mr. Manilow breached clause 14 by commencing the Californian proceedings in respect of the purchase price, except there's an issue about
Yeah.
fraud in the negligence case. But in respect to the purchase price, even on my learned friend's case, Mr. Manilow had an option to sue in California. And Hipgnosis has throughout and rightly treated the question of the jurisdiction of the Californian court over the purchase price dispute as a matter for the Californian courts. It's obviously brought the motion to challenge the jurisdiction, and that's going to be heard on the 18th of April. There has been no application for an anti-suit injunction, and it's hard to see how there could be an application for an anti-suit injunction on the purchase price dispute in the circumstances. And so that means in our submission that if this court does not decline to exercise jurisdiction, the risk of parallel proceedings and inconsistent judgments remains. The only cure that this court can offer to that diagnosis to avoid the risk in question is to decline to exercise its own jurisdiction.
But all the submissions you're making to us can equally be made to the court in Los Angeles. And at the end of the day, it can't be right, can it, that we, just simply because it comes before us first, that the English court would say, well, there can't be duplicate proceedings, so therefore we have to stay these proceedings. The question is, which is the more convenient forum?
Well, my lord, at the moment, the position is that the proceedings in California are on foot, and this court...
We have to assume, don't we, that if duplication of proceedings is the key issue, then the California court will act appropriately as a matter of comity. We have to decide which we consider to be the natural or appropriate forum, and if it is the English court, it may be the burden should be put the other way around. Can you show it isn't the natural forum? If it is this court, then surely the right approach then isn't for us to say, oh yes, but we can't have duplicitous proceedings. We are entitled to act on the assumption that the court in California will reach the same decision and will stay the California proceedings, if that is the key issue.
My lord, in my submission, that would be a dangerous assumption to make. One can't prejudge what the Californian court will decide on the 18th of April.
No, but we have to act on the assumption that they will take the same approach as you are inviting us to take.
My lord,
Do we not?
no, my lord, I don't think that's right. I'm not an expert on the United States rules on the conflicts of laws, but that's plainly not the same as here. Obviously, we've seen from the arguments that my learned friend Mr. Sutcliffe showed the court this morning that there is this argument about duplication and who went first and so on in the US proceedings, but it would be dangerous for this court to choose to exercise or not exercise its jurisdiction on an assumption that the Californian court will not exercise its jurisdiction.
But that means in that case that even if this court is the natural forum or the most convenient forum, on your argument, we would have to stay proceedings to avoid duplication.
My lord, yes,
In
because
favour of the court that isn't the natural forum, which just can't be right, can it?
well, my lord says it's not the natural forum, but it is a forum that the parties agreed could be.
That's the trouble, because that goes back to the jurisdiction. If we're looking at it in terms of discretion, my lord must be right, mustn't he? I mean, obviously, one of the factors is the risk of inconsistent judgments. We all know that. But there are plenty of other factors, and as he just pointed out, he said English court is best placed to decide questions of English law.
Well, my lord, yes, but from the Californian court's perspective, it may take the view
Well, that's
of the
what the
construction.
Californian court does is a matter for the Californian court, but we can only decide questions of discretion. We're being asked to decide questions of discretion, or whether Mr. Justice Marcus Smith has exercised his discretion correctly, assuming that he was exercising his discretion at all, which it seems to me is debatable, frankly. And that it must be a matter of English law, not a matter of what would happen in California.
My lord, that's exactly my submission. That was my attempted answer, if I may put it that way, to my Lord Justice Phillips. which is one can't assume that the Californian court is going to reach a particular view. And so the safe working assumption has to be, as at this moment in time, the Californian proceedings have not been stayed or dismissed. So the risk still exists. And the question is today what the court can do, unless it decides to park this issue until after the 18th of April and just deal with the issue of construction, which will be one way through it.
Sorry, just repeat that point.
So one way through it would be for my lords to reach a conclusion on the construction, but not deal with the submissions that I'm making on discretion until after the 18th of April. But if my lords aren't going to do that, then as at today's date, exercising the discretion that my lords have, the position is that the Californian proceedings haven't been dismissed, and it's not a safe assumption to assume that they will be dismissed because they'll reach the same conclusion as my lords on the construction of the agreement or the relevant factors.
Right. Okay.
Now, my lords, it is true that the English proceedings started before the Californian proceedings, but in my submission that should carry no real weight because there's no strict lis pendens first in time to issue rule. In this case, the discretion is much more flexible than that. And in exercising its discretion, it should obviously take into account the circumstances at the time of issue. Now, my learned friend Mr. Sutcliffe took my lords to the correspondence this morning.
Yeah.
There was one letter which he referred to but didn't hand up. With my lord's permission, I would just like to hand that up briefly.
Has Mr. Cullen been forewarned of this?
No. Can I have one copy, sir? It's the second August letter. You see it?
It's without prejudice. No, I do object to this going in. It's part of without prejudice correspondence.
Where does it say without prejudice?
It's
That's what it says.
counter offer to demand. It's part of a chain of without prejudice correspondence referring to counter offers and offers of the making.
No, I'm not.
Okay,
This court will not countenance that.
My lord, that's understood. That's understood. It was simply to meet the
If
submission.
it's part of without prejudice correspondence,
Shouldn't
It's not marked.
It's not
Shouldn't-
marked. We're not going to
but it-
resolve that. It's not going to help us.
My lord, I'm not asking the court to resolve it. It's not marked as without prejudice, but I'm not going to get into it. The point I was simply going to make was that there was correspondence that continued between the parties after the 2nd of May, before the issuance of proceedings. That
Well,
was
we were told that this morning. That there was further correspondence, and Mr. Sutcliffe, it's perfectly obvious that there was. But unless there's something that was going to help us that was in open and is before the court,
well, my
you
lord,
can't just produce rabbits out of hats at
my lord, it wasn't my
20
intention.
past 3, whatever time it is.
Why didn't I get it earlier?
I apologise to my learned friend. I should have raised it with him at the short adjournment, and we could have avoided the problem.
Forgive me, I'm really struggling there with this. You say it doesn't, it's not significant, particularly significant that the English proceedings are being commenced first. But on the hypothesis on which we're now addressing it, that the claimants are right on the issue of construction, the claimant commenced proceedings in jurisdiction of the governing law of the contract pursuant to an exclusive jurisdiction clause, and you agreed to submit to that jurisdiction. And on the face of it, and as the judge in fact held, that would entirely properly commence proceedings as a matter of jurisdiction validly served upon you. You were perfectly entitled to bring your claim under the second clause of the contract, but you chose instead to start duplicative proceedings in California, and you chose to add to them claims which plainly you were not entitled to bring in California, but should have been brought, and all of those claims could properly be heard together in this jurisdiction. I cannot see any basis upon which you can say that we should stay these proceedings in favour of the proceedings which are improperly brought in California. And I just don't understand it.
Well, my lord, let me make one final attempt before I sit down. The proceedings as to the purchase price in California are not
But we've got to look at the proceedings as they're presently framed, which you are asking to say we should stay in favour of those proceedings, and those proceedings include claims which you have not even attempted to say today are properly brought in California. Now, why should we not say that the proper place to bring those claims is here, and that's a very good reason not to stay these proceedings? Those proceedings should be stayed and brought here.
Because, my lord, the stay is only concerned with the purchase price. So the relevant question.
Yeah, but that's not the point. The stay may be only in respect of the purchase price. But the continuation of the California proceedings as they currently stand includes, as my lord says, claims which are not properly before the California court. They should be before this court in accordance with clause 14.
Well, my lord,
And there's been no attempt to say, well, we'll abandon those claims or we won't pursue them. It's been a very valiant attempt to suggest there's no longer a dispute about the Sony receipts. And we'll hear Mr. Cullen as to how correct that is. But the fact is there's been no acceptance by your clients that the claims that they bring for fraud and negligent misrepresentation shouldn't be in California at all, but should be in England.
well, my lord, that's a live issue for the 18th of April in California.
It can't be a live issue with respect. As a matter of English law, which is the governing law of the contract, those are claims which fairly and squarely fall within the second sentence. There's just no basis whatsoever suggesting they fall within the fourth sentence.
Well, my lords, I don't think there's anything I can say to assist my lords on that point, I'm afraid. But the simple point is that Mr. Manilow had communicated a fixed intention that he wished, if litigation was to be commenced on the purchase price, for that to be litigated in California before these proceedings were commenced. And so, in a sense, if one's talking about choices which led to duplicative proceedings,
He also
the point is on both
anticipated that
sides.
proceedings would be commenced here. And he allowed, because he delayed bringing his claim, the purchase price, until after English proceedings had been commenced.
My lord, we say he can't be faulted for that in circumstances where there was an attempt to settle the proceedings. All I can say is that the letter from Clinton's on the 12th of August was a bolt out of the blue.
Well, it's certainly right that Mr. Manilow's US attorney envisaged, indeed invited, claims to be commenced in London. I mean, that at least is true. I mean, forget the question of delay for a second. But But he said, you know, we'll sue you for the purchase price in the US and you can sue for peanuts in England. Now, the claim for peanuts has been made, and doubtless for good reasons. It was a very quick attempt to admit the claim. Where I understand it's got to is that it's accepted there ought to be an account. But that's still an ongoing court process, isn't it? I mean,
Yes, I think that's a fair
so
observation.
I mean, there will be continued proceedings in the UK anyway.
If a number isn't agreed, yes.
Well, it doesn't seem to have been agreed, or at least, I mean,
It's not agreed as at today's date.
no. And what doesn't also seem to have been agreed, I think, is the number of payments that might have been made. Although I can't quite get that. But if that's so, we're going to have duplicative proceedings anyway. So why, if on the first argument your banner under which you were applying was one-stop shop, why does that cease to be the appropriate banner when we're coming to exercise discretion?
But because, my lord, although there will be parallel proceedings on the hypothesis that my lords exercise the discretion as I'm inviting the court to exercise, they won't be duplicative. You will have hermetically sealed proceedings in the US dealing with at least the question about whether additional purchase price
You
is
say
being
hermetically sealed. What's the provisions for set-off? Can you remind me? Are there provisions in relation to set-off in the agreement in relation to the purchase price and anything else?
There's provisions in respect of not being able to use purchase price to set off obligations to pay a royalty, which is the point.
So there's a no set-off or counterclaim in respect of the claim for royalties.
Yes. So for the account here, if an account is taken, we can't say, well, we shouldn't pay because you've not paid us the additional purchase
What
price.
about the other way? Can it be said that they can be set off against the purchase obligation to pay the purchase price?
In California.
Well, forget where, just for a minute. Is there anything stopping Hipgnosis from saying, if we're liable for the purchase price, we have a set-off in relation to royalty payments?
I don't think there is a set-off clause going the other way.
No, so,
No,
or
it's no
so no
set-off
set-off.
going
So in
the
other
other
words, they could be set off. So set off would be governed by what? English law?
It probably would be.
And yet that's a point that can't be taken there. I mean, how's that taken in the California proceedings?
Well, there isn't. It's just a declaration, I think, that we're talking. It's the conflicting declarations.
Yes, but you have to establish settle. You have to
Yes.
prove. You have to establish that there is a sum owing the other way. How's that going to happen in California? Because the claim which Gnosis wish to set off on this thing is a claim to be determined in England, isn't it? On the account or otherwise.
Well, there's always difficulties at the borders where one separates
Yes.
out.
You said it was hermetically sealed.
I think my
I'm
lord
just
is
trying to push a great big hole into it, actually.
I can see my lord is trying to push a hole into that submission. I mean, frankly, it would be a matter for the American attorneys as to whether, in response to a claim for a declaration about the additional purchase price, whether they wish to raise the royalties point in California. That would be a point raised by Hipgnosis in California in response to the additional purchase price. claim.
They've to establish the liability which they wish to
Yes.
set off, there's an exclusive jurisdiction clause in favour of London.
My lord, yes, on Manilow and Mr. Collins.
They've got to establish
Construction,
that.
which is where we are.
So your nice hermetically sealed purchase price doesn't look very attractive, does it?
My lord, ultimately, we say it's what the parties agreed. On both sides, we agreed, the parties agreed that purchase price disputes can be pursued in California, even if other disputes are being pursued in London. It's a product of the parties' agreement. I don't think I can take it further than that. My lords, unless I can assist you further, I was going to hand back to Mr. Suckling to finish the submission.
In response to my Lord Justice Snowden's attempt to put a hole into my learned friend's hermetically sealed arm.
Testing his hermetic
Testing
seal,
is
shall I say.
exactly testing. I'm not sure, with respect, that there is a problem there, because the royalties claim, as your lordships have agreed, is still live. The claim has been admitted, but the account is going through the process. The parties can't agree what the correct number is. It will be determined presumably by a master. But the position in relation to that is that it will be resolved in this country. The purchase price claim is one where effectively there are declarations sought each way, which would be a matter that could be determined in California. And although my lords say, yes, this is a matter that's governed by English law, of course it is, but there's no reason why a Los Angeles court can't determine what the parties agreed in their natural ordinary meaning under English law. And so, as a matter of discretion, what my own friend Mr. Day says about the risk of parallel proceedings with inconsistent judgments is still a factor, an important factor, that goes beyond the convenience test.
Yeah, we've got that point. Is there anything else?
And I think you've got my submissions on construction. So unless I can assist you further, those are my submissions.
Thank you very much, Mr. Sackler and Mr. Day. Thank you. Mr. Cullen.
My lords, yes. First of all, in relation to construction,
Yes.
although this point I think is relevant to discretion and the hermetic seal that we've heard about. Because the way Mr. Sutcliffe put it is that the parties must be taken to have intended, in line with the one-stop shop presumption, that there is a clear dividing line between purchase price disputes and anything else in the world, and that therefore it makes rational sense for the parties to have agreed exclusive jurisdiction for that to go to the court of the defendant's choosing, and that wouldn't cause any particular problems. But as I think my Lord Justice Snowden pointed out, that's really not a safe assumption that one can attribute to the parties as to what they contemplated at the time, because life isn't that simple. And one can actually see that from the defendant's own fraud and misrepresentation claim in this case. The fraud and misrepresentation claim, so your lordships understand, the relief they're seeking is not apparently rescission of the acquisition agreement. They're claiming damages. And the damages in the complaint aren't specified, but one can see the clearest articulation of the way they put their damages claim in the response to the motion to dismiss.
Yeah.
This is in the supplemental unagreed bundle.
Yeah.
If your lordships look behind tab 2,
Yeah.
and you can pick it up with the paragraph beginning applying this framework.
Sorry, which page?
I'm sorry, page 40. I'm very sorry.
Page 40.
Yes.
Yes.
Now, if you're about 4 lines in, there's a sentence beginning, plaintiffs allege that defendant refused to pay plaintiffs the additional purchase price payments due under the MCAA. And this is where it gets relevant, as well as failed to carry out any of its promised strategies to promote Manilow's music catalogue during years 1 through 4, the result of which was, inter alia, to keep the cash income received by the defendant from the subject masters below the amounts required to meet the conditions precedent for payment. And then it refers to the complaint, and the paragraphs of the complaint are being referred to other fraud and misrepresentation claims. Now,
Sorry, where does it do that?
it refers to the complaint paragraphs 39 to 44 and 48.
Oh, yeah,
Those are the cross references.
that's fraud, is it?
Yes, my lord, and I can. 39 to 40, yes, 39 to 44 is fraud, and 48 to 53 is negligent misrepresentation. Now, I'm not going to debate the merits of the fraud and misrepresentation claims, but what's important is for the court to appreciate that the damages claimed as a result of the fraud and misrepresentation are the additional purchase price which would have become payable. And in order to determine the additional purchase price which would have become payable, the court determining the fraud and misrepresentation claims is going to have to form a view on the issue of construction, which divides the parties. Because until you have formed a view on the construction of the clause under which the additional purchase price becomes payable, one cannot reach any conclusion as to the damages that might be recoverable for the fraud and misrepresentation. So this is but one example of how the compartmentalization that my learned friend says must underlie the parties' intentions does not work. I will come back to this in the context of the discretionary exercise. But the simple world that Mr. Sutcliffe inhabits, whereby there are clean lines between these various claims, does not exist. And that's one reason, among many, why the approach he invites the court to take to construction does not work. One cannot hermetically seal the disputes in relation to the purchase price so as to enable it clearly to be seen that they can be litigated separately without any difficulty, because they can't. That is why the proper approach to the construction of the clause is the simple one. It's the one that is clear on the face of the language, namely that the fourth sentence is not creating an exclusive jurisdiction for disputes related to the purchase price.
Can I just go back? Just in this paragraph you've taken us to, it says, so applying this framework, the plaintiff's claims fall squarely within the provision of the contract's forum selection clause, which permits the plaintiffs to bring claims related to the purchase price in this forum. Yeah.
Yes.
And then it says, under applicable law, any claim having some logical or causal connection to the purchase price is encompassed by the scope of this provision. What's the applicable law that they're saying is applicable?
I think they're saying English law.
Well, where's that? Sorry, I'm not.
It's
Oh yes, I've got you. Sorry.
line 6. Under applicable law, any claim having some logical or causal connection to the purchase price is encompassed by the scope of this provision. And then there's a citation to something that looks like a US authority.
It is. Yeah.
The argument, as I understand it, being advanced in California, not one that Mr. Sutcliffe or Mr. Day was inclined to adopt, with, I think, very good reason, is that the fraud and misrepresentation claims are claims related to the purchase price for the very reason that I've identified, i.e. that you need to form a view on what the clause means. Now, as I say, Mr. Sutcliffe and Mr. Day don't.
Sorry, I was making a very much simpler point.
Sorry.
I thought that appears to be a reference to the interpretation of the breadth of the words related to the purchase price in clause 14, which surely is governed by English law, isn't it?
One would have thought so, my lord. I can't speak for the draftsperson of this document.
But
my lord, at all events, the argument being advanced in California is that the fraud and misrepresentation claims also fall within the fourth sentence, as I understand it. But as I say, that's not an argument which Mr. Sutcliffe or Mr. Day adopt, and in my submission, it's plainly, transparently a bad argument. So, my lord, coming back to the position more generally in relation to construction, my learned friend took you to the BNP cases and the like, but ultimately this comes back to what the language of clause 14 is. And he at various points restated it, and all his restatements of what clause 14 means, and in particular the fourth sentence, all effectively skated over or ignored entirely the critical point about clause 14, which is that it applies only to claims brought by the defendants. It's that critical point, which is the common feature with the LMA clause, and it's that critical point indeed which Mr. Justice Popperwell relied on specifically in paragraph 40 of Mauritius Bank, as being why the fourth sentence tells you nothing about and cannot assist the court in relation to proceedings begun by my clients, as they were obliged to do under the second sentence. And if one considers the language, my learned friend, I think, really can only refer to two things. He refers to the words notwithstanding the foregoing, and on any ordinary use of language, my lords, that simply won't do the heavy lifting that my learned friend requires of it. Because all it is plainly referring to is a carve-out in relation to claims made by BM, and it comes back to that point. It cannot do what my learned friend wants, which is, as he says, effectively mean that in relation to any claims by either party related to the purchase price, the second sentence is written out, deleted. Notwithstanding the foregoing will not help him. And then the other words he says are important is a submission to jurisdiction in the final clause of the fourth sentence. But what he omits to notice is that that submission to jurisdiction is solely in connection with such claims. Such claims plainly being a reference back to any claims made by BM against Hipgnosis. So the words of the clause are absolutely clear. And any attempt to construe them in the way my learned friend wishes to require one to ignore language, write in a whole new set of language to give rise to the desired effect. And then one comes to consider, well, what is that desired effect? And that desired effect is frankly ridiculous. Because that desired effect is, as we've discussed, in substance, that my clients cannot pursue claims related to the purchase price. And one has this ridiculous scenario posited that were my clients to commence a claim for restitution for overpayment, the defendants could stop that claim in its tracks by electing to start proceedings, I don't know, for a negative declaration in California. And therefore, the English proceedings would have to stop. And my clients would have to go over to California to litigate that claim in circumstances where, in fact, on analysis, they wouldn't be able to, because they couldn't advance a counterclaim for the money in California, because that would be in breach of the second sentence of clause 14, even assuming that procedurally the rules in California permitted it. And the Peanuts letter makes it clear what the view of its author is. His view is that one couldn't prosecute a counterclaim in California in answer to any claim brought by the defendants, and he presumably reaches that view because he's looked at clause 14 and he sees that any claims brought by the claimant can only be brought in London. Right. So on this scenario, we have a claim for restitution. We can't pursue it in London. We can't pursue it in America. And even if that were wrong, and even if somehow one rewrites the language and finds that actually, by some means, it would be permissible for us to pursue the counterclaim in California, can that really be what the parties intended?
Well, as I understand what's been suggested by Mr. Sutcliffe is that you can start proceedings in London, but that you lose that jurisdiction when Mr. Manilow exercises his option, which entails that presumably what he suggests you're supposed to do is to voluntarily discontinue the English proceedings.
Yes.
Failing which, what happened in this case will happen, which he will come and have your proceedings stayed because you've lost jurisdiction. So it seems that almost what's happened here is almost what he says should happen.
Yes. With all the wasted cost that involves.
Yes, because unless you voluntarily discontinue. But one thing I wonder about is what if you left it rather late and the proceedings you'd started here were near the end of the limitation period? Well, at that point, you would have commenced proceedings within the limitation period, but you have to discontinue. And
Yes.
they're outside the limitation period.
Yes, and indeed, perhaps if the timing were particularly tight, my learned friends, they could tactically wait before making their election until the limitation period had passed, and then play their trump card and prevent me from pursuing the claim.
Yeah, I think if that was the scenario, they'd probably say it's your own fault for leaving it so late.
Possibly, but the point is, these sorts of considerations cannot possibly be what the parties contend.
Well, that's, again, I know we haven't got it, but that's exactly what was said in this court in CAU in the Suez. Because you can have other situations, for instance, no longer applicable here, but under the Lugano Convention, you had jurisdiction to bring Part 20 claims which were related. But when do you judge that? What if the original claim has settled or discontinued by the time a jurisdiction challenge is made? Do you judge it at the time the jurisdiction challenge is made, or do you judge it when the proceedings were issued? The answer is you judge it when they were issued. And that was also the decision of the House of Lords in Canada Steamship.
Yeah.
So, I mean, it's not this idea that you somehow judge jurisdiction at a later date is contrary to clear, powerful authority.
Yes, but I think my learned friends put it in a slightly more modified way. And it's not entirely clear what it is, but it's something. I think there was some discussion between Mr. Day and Mr. Sutcliffe, which led Mr. Sutcliffe to say it becomes the case that the court will not exercise the jurisdiction that it formerly had.
But that's a stay on discretionary grounds, isn't it? There's no other basis.
My lord, one would have thought so. But my lord, none of this bears any relation to what the contract says, and one really doesn't need to wrangle with the possibilities in circumstances where the wording of the contract is so clear.
Well, the difference between you is the qualification which the words notwithstanding the foregoing introduce to the second sentence. As I understand it, you say it qualifies the exclusive jurisdiction of the English courts bit, because it has to, because if they bring the proceedings in California as they're plainly entitled to do, it's not exclusive jurisdiction. They say it doesn't just qualify exclusive jurisdiction, it qualifies irrevocably submit as well, because they have an option which entitles them to withdraw the irrevocable submission. And there you have it. Is that about right?
That's probably about right, my lord, but it rather skates over the difficulties inherent in what their version of events is.
Oh yeah, I'm not suggesting, sorry, I'm just
that's-
delineating the battle line
that's
as
some of-
opposed to
yes.
the arguments employed about it. But if we're looking at the words, that's I think the extent of the difference between the parties on the result interpretation.
Yes, but to get to where my learned friends want to get, you effectively have to ignore the fact that following notwithstanding the foregoing, it refers only to claims made by BM related to the purchase price. And one has to write in something different. One has to write in any claims related to the purchase price. And that leads you to the conclusion that my client can't commence claims related to the purchase price, or alternatively can commence such claims, but at the risk of having them thrown out when...
Well, I think Mr. Sutcliffe's position was you were entitled to commence the proceedings, but the moment he exercised his option, they were somehow disappeared in a puff of blue smoke.
Yes.
Yeah, provided his actual submission hasn't subverted his contractual submission.
Yeah.
Yes, although, my lord, that's...
There's no waiver.
Sorry, Mr. Sutcliffe, what?
I raised the point that it could be waiver, but no waiver is alleged here.
No.
Well, that raises another point, which is that my learned friend says that, well, if he's submitted to the jurisdiction, then all bets are off, as it were, for his...
Well, there are all sorts of problems with it, because irrevocable submission is pretty strong stuff. And it doesn't say irrevocable, and it's a point I made to Mr. Sutcliffe. If it said each party irrevocably submits, and then instead of for all purposes, subject to the fourth sentence below, then that might be a different position, because then you could say, well, the whole thing is qualified by the fourth sentence. But that's not what it says. It says irrevocably submits for all purposes.
Indeed. It's the strongest possible language, and the notwithstanding the foregoing is followed by a tight and clear carve-out.
There's a clear carve-out, and the submission to the jurisdiction is not an exclusive submission. It's just a submission in relation to claims by the defendant. Indeed. For the purchase price.
Indeed.
For all it is.
Indeed. And we say that makes it's perfectly clear how it should be construed. Yeah. I was going to move on just to deal with discretion very briefly.
Yes.
And to say, to make some observations in particular about the risk of irreconcilable judgments, which I think lay at the heart of what Mr. Day said on this point. First of all, this isn't a case like the ones that he took you to, where one has multi-parties involved in different litigation in different jurisdictions, where if Court A decides something, that would have consequences for the parties, and if Court B decides something different, it can result in a liability falling between a gap. I can describe that very elegantly, but I hope you see what I mean, where if one party is blaming the person carrying goods, and he needs...
That was the El Amria.
All of those sorts of cases. This is quite different. This is exactly the same parties. Party to litigating the same issue. Ordinary rules of res judicata and issue estoppel and things would be likely to apply, is point one. The idea that there will actually be irreconcilable judgments given by one court or another is frankly very unlikely. Secondly, my lords, it's a risk obviously created entirely by the defendants acting as they have done. Thirdly, if the American court decides as in accordance with the contract, then the result of what's going to happen is that this court is going to be seized of a fraud and negligent misrepresentation claim, in addition to the ongoing accounting claim, which I took the court to the correspondence earlier, but I think we've established remains outstanding. The English court has exclusive jurisdiction over those claims on any view. And as part of the negligent misrepresentation and fraud claim, for reasons we've touched on, the English court is going to have to form a view on the meaning of the clause dealing with additional consideration. So even on my learned friend's analysis of things, there's a problem. And
You
a
say additional
problem.
consideration in the additional purchase price.
I'm sorry, yes.
Yeah.
So even on my learned friend's analysis, there's inevitably going to be a problem if it's really a problem. In the real world, it's not going to be a problem. A number of ways might be seen to cut through this. First of all, the American court, I would submit, is likely to give effect, at the very least, to the contractual provisions, and the contractual provisions are to the effect that it's this court which has jurisdiction to deal with everything, and only this court. And similarly, it might happen that the defendant will see sense. I think two of your lordships was in the Clifford Chance case earlier this year, where there was a negative declaratory relief sought by Clifford Chance, and I think the end of that judgment finished with the possibility they recognised that the French litigants might see sense and just be happy to have the whole thing resolved in England. And one can perhaps predict that a similar course will take place here. At all events, this court is seized of an action which was properly commenced, and for all the reasons which your lordships know, English law, the rest of the claim, i.e. the Sony payments claim, the fraud, negligent misrepresentation claim, should be here and will proceed here. In those circumstances, ordering a stay simply makes no sense and would be contrary to what is the agreed exclusive jurisdiction clause. And in my skeleton, I put the authority to the effect that even where you've got a non-exclusive jurisdiction clause, the English court will give effect to the agreed jurisdiction unless there's some exceptional circumstance, and there is none here. Unless I can insist further.
Risk of. Can I attempt in 3 propositions to explain, because my learned friend has actually not represented my submissions correctly. I'm sure my lords may have, but I just wanted 3 propositions to explain the position of Mr. Mann. We stand back.
Sorry, hang on a moment. What is it, what do these relate to?
Construction.
Right.
Only construction. Stand back and look at this
Just give
clause
us
in
the
the
3
context of the
propositions.
agreement. Yes, the first is purchase price, the claim in relation to the purchase price concerns what Mr. Manilow is owed. It is plain he wanted that dispute to be determined in his home court, and Hipgnosis agreed to that. The second point is that phrase 4 only relates to the purchase price. The combination of notwithstanding the foregoing and submission by Hipgnosis has the effect that if Mr. Manilow brings a claim in relation to the purchase price, it overrides phrase 2 both in relation to exclusive jurisdiction and irrevocable submission.
You got that? You made that.
And the third point is that, that being the case, everything in relation to the purchase price is determined in Mr. Manilow's home court, yes, under English law. The home court can deal with a counterclaim in relation to a purchase price in any circumstance in which that counterclaim is brought.
So I mean, that is the submission that Mr. Cullen has dealt with, which is a submission that any claim or counterclaim, either side, in relation to the purchase price, has to be brought in California once you've exercised the option. Yes.
That's right.
Yeah.
That is the effect.
Well, I
And,
think we
and,
had-
and
I wouldn't say he'd misunderstood your submissions at all. I think that's what he's been addressing.
well, I wasn't sure whether he was submitting that somehow he's precluded from bringing a counterclaim, because he's
I
not.
don't think he's saying you're precluded from bringing a counterclaim. But we just don't know, do we? Because we don't know what the rules are about counterclaims in California.
We'd have to consider what the claim is here is in relation to the purchase price, and that has to be construed by the Californian court in accordance with English law.
Then sorry, as I understand it, I mean, he says, well, hang on, a counterclaim of some sort may have nothing to do with the purchase price, but it may give rise to a set-off. It may give rise to a monetary obligation going the other way. And as I understand it, that he says, well, wait a minute, both parties have irrevocably submitted to the exclusive jurisdiction of the English courts for those types of those claims.
In relation to other disputes other than the purchase price, that's absolutely right. The parties envisaged parallel proceedings, but they did not agree to the risk of inconsistent judgments on the same dispute. They just couldn't have done so.
Right. You want to say anything else?
No, Mother. Just that this morning you presaged a conversation about mechanics, given the deadline next week, and I just
Yes.
wanted to pick that up.
Yes.
But I'm in the court's hands, obviously, as to.
I think it would be sensible if we were to retire for a moment, just to consider the position. And we come back and perhaps we can have that debate when we come back.
Oh, okay.
So don't go away, so we're on the phone.
Call rise the table.
My time.
John, yeah.
Yeah.
Absolutely.
Trip to Baldy. Oh. Yeah, we've got too much to do today. Too much to do. Patrick and I are on finishing the message. To London. Oh, I love this. You're staying in Singapore for 2 weeks? Oh, I think you told me that. Oh. They've renamed it, haven't they? Singer Vegas. No, but it is like, I'd say it's like that. With the big, they tapped into the sort of Macau style. I mean, we're not in a it's just no. But they banned the locals, is that right? Casinos, locals are allowed to go to casinos. I thought that was Singapore.
It's also KL.
I thought that was.
Some KL places are only Chinese allowed. Unplanned boats, all the casinos on there.
I thought that was Singapore as well. It's so cool. Because you just say if the stupid foreigners want to come in and give us bang, they gambling dollars. We're not having population. Maybe they, yeah. Well, I'm not sure. Do it. Yes. I think that the quicker we get a single word style and go over here and you just got to find the we've got to find the right dictator.
Yeah.
We see
Matty Healy might be good.
Matty, yeah, whatever dictator.
Like Manatee. That's right.
The only crisis written down is no, it's a serious question, isn't it?
Don't actually this time, but again, but we always have one.
Yeah.
But they don't have one for the last 3 years. It's crazy expensive, yeah, it's insane.
Just to not to buy the car, just to be able to drive a single.
Yeah, like there's very like look at cars in Singapore versus like but also it's cheap.
Is court ready? Court rise if able.
Well, thank you very much to all of you for your helpful submissions. The position is this. The appeal will be allowed on both on as a matter of construction of the contract and on the issues of discretion, which means that the stay of the English proceedings will be lifted with immediate effect, so the English proceedings are on foot. In terms of where that leaves you for the proceedings in the United States, we'll hear any submissions you want to make. If the hearing in California is going to proceed on Friday, come what may, then we will obviously do everything we can to get a judgment to you before the end of term. But realistically, I think one has to recognise that might not be possible. It may be that the sensible course for you to adopt would be to invite the American court to adjourn. We certainly, what we were contemplating is that we would produce a short order on Monday recording what you just said, we would be quite happy if you tell the American court that's what's happened, given that it's whatever time it is in the United States. I forget how many hours behind us they are in California. I think it's about eight, isn't it? It's about 8 hours, so it's probably only about 8 o'clock in 8:15 in the morning. So, but if what we would welcome, apart from anything you may want to say now, is knowing at some stage as early as possible next week whether the case is going to go ahead on Friday. Because what I don't want to happen is for the court to have to, as it were, bust a gut producing a judgment before the close of business on Wednesday, in circumstances where we might need a little bit longer if we had it. You follow the point, Mr. Sutcliffe?
Of course I do.
My lord, we can certainly make inquiries of California counsel. I think in the past, when such inquiries have been made, often it's quite difficult to get a clear answer as to what the court will or won't do. I suspect the Californian court would be more inclined to act on an agreed position. So if both parties said to the court, "Can we vacate the dates?" then that would be helpful.
Well, we can't force that on either of you, but obviously that makes sense. But what I'm really saying is, if you could let us know preferably on Monday morning,
we will
clocks what the position is, then
we'll do our utmost to do that.
we will proceed on that basis. But for the present, as we've indicated, the appeal will be allowed on, as it were, on both construction and discretion, and the stay will be lifted.
And your lordship's mentioned a draft, an order being made to that effect. I think the order will also need to provide for a time within which my learned friend will put in an acknowledgement of service for then the action to proceed here. And then in relation, I think that will leave costs, which I don't think probably we want to deal with now. You have to
we
receive.
can't deal with those now. But I mean, in the normal course, what will happen is, whether it's sometime next week or slightly longer, you'll get the draft judgment in the usual way, on the usual basis. I mean, if it transpires that the US cause is not prepared, or either one of you doesn't, and I'm acutely conscious that it won't be people in this room necessarily who are making the relevant decisions, but if the American attorneys say we're going to go ahead come what may, then it may be that what we produce is something which will be subject to editorial corrections. So we won't have the usual course in which you have an opportunity to, not to invite us to change our minds, but to invite us to correct our grammar. You may just have to forego that, and that may have to be dealt with at a later stage. Obviously, if it transpires that Friday will not go ahead, then we'll just deal with it in the normal way, and we'll let you have a draft judgment in the normal way for typographical corrections, and you can deal with questions like costs and so forth
After that.
as part of the consequentials in the usual course.
It's suggested behind me, if we can tell the Californian court that the judgment, when it arrives, will deal with issues of English law construction of the contract, then that might assist, and I take it we can tell the court.
I think one thing you can both agree about is one thing that will deal with is questions of English law about construction of clause 14 of the contract.
I'm grateful, my lord.
All right.
Well, we will be in touch next week.
Okay. Subject to that. Thank you.
Yes.
Thank you very much for very helpful submissions, and I hope we didn't give you too hard a time, Mr. Sutcliffe, but even though the appeal has been allowed, we were.
I think your lordship gave Mr. Day a much harder time. So
Well, maybe we did,
I'm
but
grateful. But
Mr. Day's had that experience previously with one member of this court.
he certainly has. No, my lord, it's all in the day's work.
Well, thank you very much indeed. And when the time comes, do have a good vacation.
Court rise in favor.